ever expect to be hauled out of your house, put on a train, and marched into a gas chamber and be choked to death? There is something in all of us that, no matter how terrible it is, that we want to live another day.
The Chief Prosecutor for the United States of America.
The privilege of opening the first trial in history for crimes against the peace of the world imposes a grave responsibility. The wrongs which we seek to condemn and punish have been so calculated, so malignant and so devastating that civilization cannot tolerate their being ignored, because it cannot survive their being repeated. That four great nations, flushed with victory and stung with injury, stay the hand of vengeance and voluntarily submit their captive enemies to the judgment of the law is one of the most significant tributes that power has ever paid to reason. This tribunal, while it is novel and experimental, is not the product of abstract speculation, nor is it created to vindicate legalistic theories. This inquest represents the practical effort of four of the most mighty of nations, with the support of 15 more, to utilize international law to meet the greatest menace of our times, aggressive war.
Greetings to you all. My name is Benjamin Ferenz, and I'm speaking to you from Delray Beach, Florida. I am 100 years old and the sole surviving prosecutor of the Nuremberg trials.
Now let us tackle a significant phenomenon that shaped the international legal system of today.
Let me refresh or enlighten you on the fall and capture of the Nazi leadership. Hitler, having announced to his generals that the war was lost, committed suicide with his wife of 2 days, Eva Braun. Then his trusted allies followed suit. After the war, the Allies occupied Germany, outlawed the Nazi Party, and worked to purge its influence from every aspect of German life. The party's swastika flag quickly became a symbol of evil in modern post-war culture. Although Hitler killed himself before he could be brought to justice, a number of Nazi officials were convicted of war crimes in the Nuremberg trials, which took place in Nuremberg, Germany from 1945 to 1949. The word is Nuremberg. I think everyone might have come across or heard what happened here. Nuremberg is the place where the major Nazi war criminals were on trial before the International Military Tribunal, or the Tribunal. Norman Burkett, the associate British judge, called it the greatest trial in history. U.S. prosecutor Telford Taylor, even more involved in later cases, wrote that Nuremberg was conceived as an episode that would leave an enduring judicial monument to mark as a giant step in the growth of international law. Many may think that after this historical event, international law has been followed to realizing international criminal justices. However, during the second half of the 20th century, crimes against humanity and mass killings abounded, not only in Yugoslavia and Rwanda, but in Cambodia, Bangladesh, Kenya, Zimbabwe, and many other countries. Only after the end of the Cold War did international criminal law begin to flourish. With the establishment of the ad hoc tribunals, various hybrid mechanisms, and the International Criminal Court. So, why am I referring Nuremberg as a landmark? Nuremberg is a landmark for multiple legal, political, historical, and social reasons. Much writing and discussion has been dedicated to analyzing the context, the precursors, progress, outcomes, and legacies of the trial. Aside from creating a record of Nazi crimes, Nuremberg provided a model for new institutions of international law and an approximation of due process to the captured leaders of a totalitarian regime. Herein, there are major themes that establish Nuremberg as a legal landmark. First, its foundation to create a new institution of international law. Second, creation and development of new and distinct categories of international criminal liability in the Nuremberg Charter, indictment, and judgment. Third, the individual in international law runs as an undercurrent through the institutional and substantive legal aspects of the trial.
The creation of International Military Tribunal was the first move to condemn the atrocities of Nazis. Leaders like Churchill were initially not driven to the establishment of IMT as they wished to avoid overcomplication legalism due to the creation of new legal institution. And their priority is to ensure that Nazis were penalized and permanently vanquished. However, judges, lawyers, and legal philosophers pushed the need of new legal rules and instruments to demonstrate abhorrence and to guard against recurrence of atrocities committed by Nazis, and at the same time devised legal principles on which the tribunal was based. Eventually, the British agreed to the plan for trial, and America's to President Truman had strongly expressed America's commitment to the trial. However, main perpetrators like Hitler, Himmler, Goebbels, and Mussolini did not able to make it to the trial as they were all dead by the end of the spring of 1945. The international trial was backed up with several precedents, such like trial in 1474 by judges of Austria and a number of Swiss cities of Peter von Hagenbach, executive action against Napoleon Bonaparte by the Congress of Vienna, arrest and trial of LIABILITY of German war criminals in 1921 following World War I under the Articles 227 to 230 of the Treaty of Versailles, and a failed attempt to extradite ex-Kaiser Wilhelm von Hohenzollern from the Netherlands for the supreme offense against international morality and sanctity of treaties. There was also distinction of trial and international prosecution based on the nature of each forum, to the crimes tried, the law applied, and the relationship between trial and the armed conflict. On the height of deliberation of the IMT establishment, it gave birth to the creation of the Charter of the Tribunal, also known as the London Agreement. From June 26 to August 8, 1945, representatives of the four victorious powerful nations met in London to draft the agreement and the charter, and that is Britain, United States, Soviet Union, and France. And later on, it was ratified by other United States. It also had the charter has determined the tribunal jurisdiction in respect to the three substantive crimes, mainly crime against peace, war crimes, and crime against humanity. It also identified two modes of responsibility. You have commission of a defined crime regardless of superiority, responsibility, and common plan or conspiracy. The notion of common plan conspiracy allowed the Nuremberg indictment to reach individuals at the top of the Nazi power structure and the authors of Nazi political doctrine for the acts prior to 1939, not just those who carried out the orders and implemented the policies. The tribunal is composed of 8 judges in all, 1 judge and 1 alternate judge from 4 countries. The prosecutors were also nominated from each country, at the same time several leading lawyers. In that tribunal trial, there were 24 accused, 23 were arrested, 21 appeared in the trial. It is because Robert Ley, head of the German Labor Front, committed suicide before the trial began. Gustav Krupp von Bohlen-Anhebach was found medically unfit for the trial, while Martin Bormann was tried in trial by absentia. The trial began in the courtroom 600 at Nuremberg Palace of Justice on November 20, 1945 until September 1, 1946. The judgment was handed down on September 1946, while individual convictions and sentences were read out on October 1, 1946. The tribunal indictment are as follows. There were 19 accused were convicted. 3 were acquitted, 12 sentenced to death, and 7 to prison sentences ranging from 10 years to life imprisonment. 10 accused were executed by hanging on October 16, 1946. Martin Bormann, Hitler's private secretary, was never captured, was convicted and sentenced in absentia, while Hermann Goering committed suicide in his cell by taking a cyanide pill at the night before he was due to be hanged. It cannot be denied that the Nuremberg trial founded a significant landmark in the conception and the development of new substantive rule of international law as enshrined in the Tribunal Charter and the design and establishment of the Tribunal itself. The opening and closing speeches, the various legal and factual arguments during the course of proceedings, and the tribunal judgment in 1946, enshrined and soon thereafter in the UN General Assembly, the Nuremberg Principles changed and shaped the future direction of international law. Okay, there are 2 most significant innovations in the Charter. That's crime against peace, provided in Article 6 of Paragraph A, and crime against humanity in Article 6 of Paragraph C. There is also an international crime that did not make it to the Nuremberg Charter, which is the crime of genocide. In negotiating the content of the Charter, Robert Jackson, Attorney General and a serving Supreme Court Justice of U.S., sought the advices and insights of Professor Hirsch Lauterbach in relation to both crime against peace and a crime against humanity. Therefore, Lauterbach became instrumental in advising on the terminology and format for the list of crimes. Article 6 of the Tribunal Charter laid down the list of crimes classified under the 3 main tribunal jurisdiction. And to name some examples, for crime against peace, you have waging of war of aggression or a war in violation of international treaties. For war crimes, you have violations of laws or customs of war. And for crime against humanity, you have murder, extermination, and enslavement. Article 7 and 8 provided the official position of a defendant could not be invoked in defense or mitigation, and that the superior orders could be considered not as defense but as a mitigating factor in respect with the punishment, while Article 9 allowed an individual member of the organization to apply to be heard in the questions of criminality. Indeed, because of its innovations of procedure and principle, Nuremberg represented the first tribunal that could properly be have or called international in character, because 23 nations signed up to the London Agreement and the Charter, representing a significant proportion of the international community of states at that time, and the international community through the General Assembly of the United Nations later endorsed the principles applied at Nuremberg and confirmed the understanding that the Charter and the judgment were instruments of international law.
The Nuremberg trials saw the end of the regime that caused the Holocaust and was the first time in history where an international court sentenced people to prison and to death. It would later set the stage for the International Court of Justice, the Universal Declaration of Human Rights, and 2 Geneva Conventions. Germany started the Second World War when it invaded Poland and eventually attacked over a dozen countries throughout the continent. But by 1943, the tide of war had turned. The Soviet Union had pushed back at Moscow, St. Petersburg, and Stalingrad, while the British had beaten back the German air raids and pushed the Axis powers out of Africa. So the leaders of the major Allied powers came together to discuss the state of the world after World War II had ended. Stalin of the Soviet Union, Roosevelt of the USA, and Churchill of the United Kingdom. They discussed creating the United Nations, the D-Day invention, and dividing Germany up to 4 occupation zones because Germany will be divided. Of course, that was not all. Over the course of the World War II, it became apparent to the Allied forces that Germany committed atrocities in a massive scale. The night raids, the killings, forced deportation, and mass genocide. There was only one question in everybody's mind. It was, how do you punish such an evil act? To this question, there were basically only 3 answers. The first was to do nothing. To let all the atrocities, all the death, all the destruction go unpunished. But how could any country consent to such a course of action? How could the far-off USA or the invaded Soviet Union or the occupied Czechoslovakia consent to such a course of action? The second option was to put all the perpetrators to death through executive action, to simply give the command to kill thousands of people regardless of whether they committed war crimes or not. But this action was disliked by both Churchill and Roosevelt at that time. And so the third option was eventually chosen by the end of the war, justice through prosecution. It was decided that the perpetrators of the Second World War and of the Holocaust be dealt a fairness and a justice that they themselves destroyed in Germany. But that brought up the next question. How do you punish someone from the other sovereign country for crimes that are not actually illegal in that country? The Allied powers answered their question with the London Charter of the International Military Tribunal. This charter laid out a system where the 4 different legal codes of France, Soviet Union, USA, and UK would be incorporated into a single tribunal. There were prosecutors and defense attorneys according to British and US laws, but decisions and sentences were imposed by a group of judges according to the French and Soviet legislation. Furthermore, 4 types of crimes were decided that a person could be indicted for. The first is crimes against peace, which included planning, initiating, and waging of aggression or wars in violation of international treaties. The second is crimes against humanity, such as extermination, deportation, and genocide. The third crime is war crimes. This basically meant a violation of the rules of war that were set forth before the Second World War, such as executing prisoners. The fourth crime is a common plan or conspiracy to commit any of the 3 aforementioned crimes. After all, simply because you did not put anyone in the gas chambers yourself doesn't mean you're not guilty of creating the system leading to such genocide. Of all the crimes stated in the Charter, there were 2 most significant substantive innovations, and that's the crimes against peace and crimes against humanity, which is provided for in Article 6 of the Charter. Crimes against peace, as stated by the U.S. prosecution, constitutes the heart of the case, and that everything else in the Nuremberg trial, however dramatic, however sordid, however shocking and revolting to the feelings of civilized peoples, is only incidental or subordinate to the supreme crime against peace. The term crimes against peace is derived from the work of RHINE, who attended the London Conference on behalf of the Soviet Union. Of the 3 charges contained in the Charter, the so-called crimes against peace have undoubtedly caused the greatest controversy. Technical questions concerning the novelty of this charge and the retroactive character of the law applied by the tribunal were vigorously contested by international jurists at that time. Did a crime of waging aggressive war exist as a matter of customary international law at the time? The Nazis invaded and instigated conflicts in countries across Europe such that it could give rise to individual criminal responsibility and be made subject to criminal charge. If the principle was not so recognized, could it simply be asserted that the Charter was making a new law? The tribunal supported its position by citing such pre-war agreements as the Kellogg-Briand Pact of August 27, 1928, outlawing war as an instrument of national policy, the draft Treaty of Mutual Assistance sponsored by the League of Nations in 1923, providing in Article 1 that aggressive war is an international crime, the preamble to the League of Nations Protocol for the Pacific Settlement of International Disputes of 1923, stating that a war of aggression constitutes a violation of the solidarity between nations and is therefore an international crime. Declaration adopted by the Assembly of the League of Nations on September 24, 1927, that war is an international crime, and the resolution unanimously adopted on February 1928 by the 21 American republics at Havana, providing that war of aggression constitutes an international crime against the human species. On October 1, 1946, in the judgment, aggression was declared the supreme international crime. The tribunal had preceded this assessment by describing the charges of planning and waging aggressive war as charges of utmost gravity. War is essentially an evil thing. Its consequences are not confined to the belligerent states alone, but affect the whole world. Secondly, despite this early use of the term, the first prosecutions for crimes against humanity took place after the Second World War in 1945 before the International Military Tribunal at Nuremberg. On the questions of legal innovation and retroactivity, it appears clear that the concept of individual criminal responsibility for crimes against humanity was novel. In older documents, the terms humanity, laws of humanity, dictates of humanity, and the like had been used as non-technically, for example, in the Fourth Hague Convention of 1907. In May 1915, the Allies used the term in a joint declaration on the massacre of Armenians. Nonetheless, the tribunal went on to make the first findings of crimes against humanity, stating that from the beginning of the war in 1939, war crimes were committed on a vast scale, which were also crimes against humanity, and insofar as the inhumane acts charged in the indictment and committed after the beginning of the war did not constitute war crimes. They were all committed in execution of or in connection with the aggressive war and therefore constituted crimes against humanity. The word genocide was first coined by Polish lawyer Raphael Lemkin in 1944 in his book Axis Rule in Occupied Europe. It consists of the Greek prefix genus, which means race or tribe, and the Latin suffix side, which means Lemkin developed the term partly in response to the Nazis' policy of systematic murder of Jewish people during the Holocaust, but also in response to previous instances in history of targeted actions aimed at the destruction of particular groups of people. Later on, Raphael Lemkin led a campaign to have genocide recognized and codified as an international crime. Nuremberg is landmarked not in the sense of being a site of recognition of the crime of genocide, but as a gateway to recognition. Nuremberg saw the first mention of genocide in a formal international legal document.
For the German troops, the war was, in effect, already long lost.
Even the young soldiers, those who could reflect, didn't believe in victory. You just wanted to survive, to come home safe and sound.
And so ended the regime that started the Second World War in Europe, committed genocide with a brutality rarely seen in history, and took the lives of 50 to 56 million people. Nuremberg remains a standard bearer. It is a place and a process to which those who advocate for individual and collective rights in times of upheaval can point in order to demonstrate that the international community will not, or at least should not, allow impunity and injustice to prevail. In a time of ongoing turmoil on the international stage, safeguarding the legacy, however imperfect, remains important.
System. Now, how are you going to do it? I will end by telling you how to do it and the principles which have guided me. There are 3 principles. 1, never give up. 2, never give up. 3, I hear you, never give up. Good luck. I wish you the best of luck.